This meeting is being recorded.
Good afternoon, folks. Like to call the January 30th, 2024 Environmental Resources Committee to order. We will begin with the Pledge of Allegiance to the flag, and also we're going to have a moment of silence afterwards, because I was reminded during rules review that the model agenda actually has the moment of silence afterwards for all agendas. So we're going to do Pledge of Allegiance first, and we'll have a brief moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, moving on to item number 3, public comment. Do we have anybody signed up to speak under general public comment?
We do not.
Okay. All right, moving on to item number 4, public comment for the Farmland Preservation Plan draft.
So we do not, we put this on the agenda because in the Farmland Preservation Participation Plan, we did say we would offer multiple opportunities at ERC for people to come and give public comment, so nobody signed up for today. We do have an open house for it on Thursday at Conservation Planning and Zoning at 210 River Drive as well for anyone who's interested in coming to give comment or talk about the Farmland Preservation Draft.
Okay, is that going to be an actionable item for next month then?
Likely, yes. We'll give an update on what comments we've received.
Okay.
So, yeah.
Thank you. Well, seeing as no one wishes to testify, we'll close that. Well, public comments, so we'll just close public comment. Item number 5, approval of January 5th, 2024 committee minutes. Motion by Supervisor Shafinsky, second by Supervisor Ritter. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Moving on to item number 6, we have operational functions required by statute, ordinance, or resolutions. A, public hearings, review possible actions and possible recommendations to the county board for its consideration. We have county zoning changes. Just ask that everybody please mute your phones and other electronic devices. If you're joining us electronically, please mute yourself unless you are recognized by the committee. Marathon County ERC is now meeting in public hearing on the location plan specifications and purpose of the following projects. We have 6A1. Lawrence Olson on behalf of Bach Properties LLC, General Agriculture to Low Density Residential, Town of Holton, and 6A2, John Sundermeyer on behalf of Bach Properties LLC, General Agriculture to Rural Residential, Town of Holton. Briefly, we'll just introduce the committee, myself, Supervisor Langenhut, Supervisor Drabeck, Supervisor Seefeld, Supervisor Overbeck, Supervisor Ritter, Supervisor Unger, and Supervisor Shafinsky. We also have staff present as well. The establishment of the ERC is required by law for purposes of administration of county ordinances and land conservation programs. The committee must follow state laws and local ordinances as written. This committee cannot change or ignore any part of the ordinances or state laws, must apply the laws as written. The purpose of this committee is to hear and decide on proposed ordinances and ordinance revisions, rezoning petitions, and provide direction on land conservation and planning programs. The ERC will give a full and fair hearing to any person applying for a rezone petition. Taped recording is being made of the meeting, which will assist with preparation of written hearing minutes. Committee was interested in hearing all pertinent comments and questions. Each hearing will be opened by reading the public notice and allowing staff to present a staff report, including evidence from any on-site inspection. The applicant and anyone wishing to testify will be sworn in and allowed to give testimony. Witnesses will be called in the order of those first in favor, second opposed, and then third as interested may appear. The committee may ask questions to zoning staff and applicant. It is necessary that we set a reasonable time limit on individual statements and on the overall length of the hearing. To promote orderly discussion, anyone wishing to present oral testimony or ask questions relating to the hearing should state your name and present your testimony or questions so it becomes part of the official record. We request you avoid repetition. Once committee has all the necessary facts, chairman will close the hearing, allowing no further testimony, and the committee will deliberate and decide in front of the public whether the applicant has met the standards in the ordinance. No additional testimony from the public is allowed during the deliberation. However, the committee may question staff for purposes of clarification. After a decision is made, the committee will proceed to the next hearing. Many of the decisions made by the committee are recommendation to the Marathon County Board of Supervisors, who will take up the matter at a future county board meeting. Please contact our staff for more information regarding the county board process. The committee will now hear the application of 6A1, Lawrence Olson on behalf of Bach Properties LLC, General Agriculture to Low Density Residential, Town of Holton, and we will begin with the staff report. All right, Garrett, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
All right, this is for Lawrence Olson on behalf of Bach Properties LLC. Petition to rezone land, staff report January 30th, 2024 for the Environmental Resources Committee. The petitioner is Lawrence Olson, residing at 100-877 County Line Road, Stetsonville, Wisconsin, 54480. Property owner is Bach Properties LLC, located at W861 County Road 8, Dorchester, Wisconsin, 54428. Area proposed to be rezoned is located near the corner of State Highway 13 and County Line Road. The petition of Lawrence Olson on behalf of Bach Properties LLC to amend the General Code of Ordinance for Marathon County, Chapter 17 zoning code to rezone lands from GA General Agriculture to LDR Low Density Residential, located in part of the northwest quarter of the fractional northeast quarter of Section 6, Township 29 North, Range 2 East, Town of Holton. Area to be rezoned from GA General Agriculture to LDR Low Density Residential is described as Outlot 1 of the preliminary CSM, parent parcel PIN as shown. Town of Holton Town Board met on January 17th, 2024. Marathon County Environmental Resource Committee is meeting today, January 30th at 2024 at 3 p.m. A legal advertisement was published in the Wausau Daily Herald. Notice of zoning change request was also sent by regular mail to adjacent property owners within 300 feet of the subject property. On January 17th, 2024, the Town of Holton Town Board recommended approval to Marathon County's Environmental Resources Committee. Staff recommendation, the rezone meets all the zoning district standards as it relates to size, frontage, access, and dimension. Based on the information provided above, findings of fact, conclusions of law, and the town's recommendation, it appears the rezone request meets all the rezone criteria and standards for rezoning. Therefore, CPZ staff recommend that the Environmental Resources Committee recommend approval to the Marathon County Board of Supervisors. Should the rezone be approved by Marathon County Board of Supervisors, CPZ staff recommend that the town update its comprehensive plan to reflect the zoning change if applicable. We do have Mr. Olson here if there are questions for him.
Okay, thank you, Garrett. Any questions for Garrett? All right, I did talk with Lori before the meeting today. Did the town actually send the resolution like today?
They did, yes.
Okay.
And we did go over it to make sure that all the boxes have been checked, and they have, and explanations provided where needed.
Okay. Any idea why it took so long?
I'm not sure, no.
Okay. All right. Okay, any further questions? All right, thanks, Garrett. All right, we will move to anyone wishing to speak from the public. Anybody wishing to speak in favor of the proposed rezone, please identify yourself at this time. I usually recommend folks get sworn in for this just in case there are questions from the committee. So if you're to speak in favor, it just takes 2 seconds, but at least you're available for questions during the hearing. So if you want to be sworn in, you can just approach the microphone in the back. Okay. Anybody wishing to speak in favor of the proposed rezone, please identify yourself at this time. I'll call one more time after this. Anybody wishing to speak in favor of the proposed rezone, please identify yourself at this time. Seeing and hearing none. I'll call once for this. Anybody wishing to speak opposed to item 6A1, please identify yourself at this time. Seeing and hearing none, I'll call once. For anybody wishing to speak as interested for item 6A1, please identify yourself at this time. Seeing as no one wishes to testify for this application, I'm now declaring the public hearing on Lawrence Olson on behalf of Bach Properties LLC, General Agriculture to Low Density Residential Town of Holton, now closed. The committee will now deliberate on the application, apply the standards of the zoning ordinance. I think a motion to approve would be in order here. Supervisor Seefeld?
Thank you, Mr. Chair. I'll make a motion for the petition of Lawrence Olson on behalf of Bach Properties LLC to amend the General Code of Ordinance for Marathon County, Chapter 17, to rezone land from general agriculture to LDR Low Density Residential in the town of Holton and forward it to the county board and to approve the conclusions of law. Thank you.
Motion's been made. Is there a second? Second by Supervisor Shafinsky. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed? Motion carries. On to 6A2, John Sundermeyer on behalf of Bach Properties LLC, General Agriculture to Rural Residential Town of Holton.
All right, this is for John Sundermeyer on behalf of Bach Properties LLC, petition to rezone land. Staff report January 30th, 2024 for the Environmental Resources Committee. The petitioner is John Sundermeyer, located at 230-201 Rosedale Ave, Abbotsford, Wisconsin, 54405. Property owner is Bach Properties LLC, located at W861 County Road A, Dorchester, Wisconsin, 54425. Area proposed to be rezoned is located just west of the intersection of Würzburg Ave and County Road F. The petition of John Sundermeyer on behalf of Bach Properties LLC to amend the General Code of Ordinance for Marathon County, Chapter 17 zoning code to rezone lands from GA General Agriculture to RR Rural Residential, located in part of the northeast quarter of Section 35, Township 25 North, Range 2 East, Town of Holton. Area to be rezoned is described as the encroachment area of the plat of survey encroachment exhibit. Parent parcel pin as shown. The Town of Holton Town Board met on January 17th, 2024. Marathon County Environmental Resources Committee is meeting today, January 30th, 2024 at 3 p.m. A legal advertisement was published in the Wausau Daily Herald. Notice of the zoning change request was also sent by regular mail to adjacent property owners within 300 feet of the subject property. On January 17th, 2024, the Town of Holton Town Board recommended approval to Marathon County's Environmental Resources Committee. Staff recommendation, the rezone meets all the zoning district standards as it relates to size, frontage, access, and dimension. Based on the information provided above, findings of fact, conclusions of law, and the town's recommendation, it appears the rezone request meets all the rezone criteria and standards for rezoning. Therefore, CPZ staff recommend that the Environmental Resources Committee recommend approval to the Marathon County Board of Supervisors. Should the rezone be approved by Marathon County Board of Supervisors, CPZ staff recommend that the town update its comprehensive plan to reflect the zoning change if applicable. And Mr. Sundermeyer is here to answer questions.
Any questions for Garrett? Similar to the first one, Town of Holton provided their resolution this morning for
Correct.
this one? Okay.
Yep, all boxes were checked and explanations provided.
Okay. And approval, of course, right?
Correct.
Yeah, okay. All right. Anything else from the committee? All right. Thanks, Garrett. All right, moving on. Anybody wishing to speak in favor of the proposed rezone 6A2, please identify yourself at this time. I'll call one more time. Anybody wishing to speak in favor of the proposed rezone for 6A2, please identify yourself at this time. Seeing and hearing none. I'll call once. Anybody wishing to speak against item 6A2, please identify yourself at this time. I'll call once. Anybody wishing to speak as interested for item 6A2, please identify yourself at this time. All right. Seeing as no one wishes to testify for this application, I am now declaring the public hearing on John Sundermeyer on behalf of Bach Properties LLC, General Agriculture to Rural Residential, Town of Holton, now closed. Committee will now deliberate on the application, apply the standards of the zoning ordinance. Yeah, and I think a motion to approve would be in order for this one as well. Supervisor Drabeck wants to get his name in the minutes. So, all right, Supervisor
Yes.
Drabeck.
Yeah, I'd like to make a motion to approve the rezone of Bach Properties LLC from, let's see if I can read my writing here, general agriculture to rural residential based on the findings of facts and conclusions of law, also the town's approval. Thanks.
Motion has been made. Is there a second? Second by Supervisor Ritter. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. All right, we are on to B, we have none. C, review and possible recommendations to the county board for its consideration. 1, opportunity for providing recommendations relative to items to be included in the administrator's 2024 annual work plan. Administrator, feel free to kick it off.
I think you did a very good job, Mr. Chair. Thank you for giving me the opportunity to seek some input from this committee. I'm taking a very similar approach to what I had previously done last year, and that is to go to each of the committees and allow for discussion relative to items of importance at the committee level, for me then to take and compile that information and present it ultimately to the full board in a draft 2024 work plan for the board's consideration and prioritization. Certainly, each of you are familiar with some of the holdover projects, the things that we're continuing to work on. I sent out previously a 2023 work plan update. And then, of course, we've had a number of conversations at this committees and other committees in the full board relative to, just for example, the negotiation of the agreement relative to the conduit bonding that was initially approved. The initial resolution was approved by this board relative to the digester project. So that's just one of the items that's on the work plan moving forward for 2024 for consideration. But happy to answer any other questions or really, Mr. Chair, just opening it up for discussion amongst committee members to, again, allow me to compile that information for the full board's consideration.
Sure, I just had a couple of things. So as far as the items currently in the work plan that the committee would have some influence on, the only ones that I saw were, obviously the relocation to the new campus is something that would impact this department. And I'm not advocating for prioritization, I'm just pointing out things that I noticed that, the committee might be impacted on. The comprehensive fee schedule to be included, that's unprioritized right now, I believe. That's something obviously we would have an interest in because of the work that we do here. And in addition to that, there's the assembly ordinance that we're going to be taking up very shortly here. And there was one other one that I had. I think it was the solid waste, or two of them. The Park Rec and Forestry Sustainability Plan, and then the landfill gas rights acquisition. Now, the landfill gas rights acquisition is in motion. Actually, it's more complete here. So I don't know if that's really in need of prioritizing. The sustainability plan, I don't recall us having that much discussion on that piece. Can you provide a little more information?
Absolutely. So this was actually a request I made of the Parks Director, Jamie Polly, and she worked with her staff to kind of put together, and I believe it was in one of your packets, a multi-stage approach to really look at some ways to ensure that primarily our capital requests that are coming through from Parks Rec and Forestry, that we consider ways to set aside revenues from some of the operations that Parks has. So just for example, campgrounds. Right now, our campground revenues are not segregated in any way to have a portion of them set aside for any necessary improvements to those campgrounds. And you deal with, if there were requests for a large CIP project at a campground, that would be addressed through the normal budget process. Similarly with Eastgate Hall, perhaps a better example. We don't set aside any portion of the room rental revenue from that activity. We don't segregate it for improvements to those facilities. And just in the 2024 budget that you adopted in November, there were significant CIP investments made. So one of the things that I had Jamie work on, and I do envision this being in the 2024 work plan, that was identified, that idea of segregation of revenue was identified as a potential avenue through which we could mitigate those CIP hits, for lack of a better term, when you'll have a large CIP project and we haven't been setting aside revenue. A really good example is the ice arena. So Jamie likes to share that the ice arena, when we purchased the equipment for that arena, and I believe it was like 1976, don't hold me to the date, we purchased it used. And we haven't been setting aside a percentage of those rental revenues to pay for a new facility. So I envision in 2024 bringing forward a formal policy to the county board for consideration. So we have kind of a consistent approach across all of our facilities. I think that would be helpful not only in parks, but also, as you know, we do have a number of non-county entities that lease space from us. We're in the courthouse right now, and of course, we have the Department of Corrections that actually leases space within the courthouse. It's not a county department, it's a state agency. They pay us rental revenue. We don't segregate in a meaningful way a portion of those revenues to set aside for improvements to those spaces, and I think that's good business practice. So I want to bring forward a proposal for the county board to consider in 2024 to really implement that across the board. So that's kind of the next step in that sustainability plan that you referenced.
Okay. Any other questions, comments from the committee? I would just say generally, the one that's ongoing that we have an interest in is in that fee schedule. And if any of the other members want to object to what I just said, that's perfectly fine. I just wanted to throw that out there for discussion. But we had a lot of discussion last year during the budget process regarding our the departments that we provide oversight for their relationship with fees relative to the levy. So I think that's something that, like I said, we have an interest in. Very last thing, and I'm only going to say this because it is included as part of the work plan. The unprioritized item M, evaluation of zoning options regarding marijuana cultivation. Now, I made my thoughts very clear about this at exec a number of months ago, but this committee will not take this up until this even becomes remotely legal, if it ever does. We are not going to take this item up. So,
I do have a little additional information on that. I've had some initial conversations with Andy Phillips, the general counsel for the Counties Association. And to your point, there is a fair amount of discussion about if it does move forward at the state level, whether it's medical or otherwise, there are highly likely to be state preemption of various levels of local
Sure.
zoning control. So I think if that's what you're alluding to, it certainly makes sense. The only other thing I neglected to mention, and certainly it's of interest to this group, but I think based on our work in 2016, it really was across the county, all of the standing committees and the full board. I think we're due for what we're terming a comprehensive plan refresh. That was in the initial 2016 plan. This idea that you'd have a periodic check-in on those plans, as well as a update of the strategic plan. The strategic plan was updated and extended through 2024. So that gets you through the end of this current year. But that isn't something that by any means you're not required to have a strategic plan. You are required to have a comprehensive plan, and your plan is still in place. It's simply that within that plan, which is available on the website, there was reference to kind of that refresh. The county board would take another look at that plan and update it. So that was one thing that, again, will be in my proposal. That, of course, does not mean that we need to move forward. If the board deprioritizes that, for lack of a better term, you're certainly able to do that.
the comp plan has to be updated every 10 years, doesn't it?
I think it's technically the comp plan it's a 20-year plan, but
Right, and they,
defer to
updated
Lori.
every 10 years, but it doesn't have a sunset to it.
Well, and if I recall correctly, there's no penalty in that statute if you don't
Correct.
do it. It's just that your land use decisions start to become a little shaky.
Yes, correct.
Yeah. Okay. Anything else for discussion? All right. Good?
thank you very much, and I will continue to work on that plan.
Okay. Moving on to, thanks for coming, of course. 6C2, Marathon County Assembly's Ordinance 12.04, review of draft updates and consideration of forwarding to county board. So this was in front of us a number of months ago, and it is back with, I'm assuming, some new information. So,
Okay, hang on just a second here.
sure.
Where's the new? Oh, this one? Okay. All right, thank you. Okay. So I'll start. Administrator Leonard might want to add a few things. We also have other staff and representatives from the sheriff's office who have been assisting in some of the recent updates. But just as a reminder, so 12.04, as it sits in our Code of Ordinances today, is considered unenforceable. So it was on the administrator's work plan. A work group was formed earlier this year to start looking at an update to 12.04. In October, we brought the first draft before you all to take a look at. We got comments from your committee, Infrastructure and Public Safety. We also did outreach to all the towns. We did outreach to Edgar Steam Show and Taste and Glow, and I'll come back to that in a few minutes. And we took all of those comments, and the work group went back to work on the document some more, including having the Edgar Steam Show participate in our work group meetings. And what we brought back before you now is the draft that the work group is asking committees to consider forwarding to county board for adoption. So one of the things I did want, or several of the things I want to talk to you about, are the comments we received and some of the changes we made based on those comments. First off, starting off, one of the comments we got was to get input from current events that are or would be applied to this ordinance if it were adopted. So the Steam Show and the Taste and Glow were specifically brought up. So we did outreach to both of those groups, and like I said, we did get participation and feedback from the STEAM show. We've been working with them to get their comments and try and incorporate some of those revisions into the draft. Taste and Glow, I think most people have heard now that it is kind of on a pause this year. The two main organizers who are behind it have said that they will not be organizing an event this year. I guess that means there could still be an event organized by somebody else, but at this point, they are not going forward. We have continued to email them throughout the process and ask for comment. We have not received any to date, so. Another thing that was brought up in the comment process was town input. How would the towns be involved in the process if this ordinance was adopted? So we did take a look at that as a work group. There's two ways in which we will involve the towns. First, the appeals section that has been added to the draft before you. It's in section 16. That does include an option where a township can appeal a permit that is issued. So they would have that option, and there's a process for doing that. The other thing we've talked about through our implementation process, if the code is adopted, CPZ would always notify a town immediately upon receiving an application, and then we would notify them the day the permit is issued. So then that would trigger the period where they could appeal, and we would, facilitate if they needed to do an appeal. That would go before the administrator as it's proposed in the draft, so they would have time to do that. There's also some guidelines in the appeal section that says what a town can and cannot appeal on, so they cannot appeal just because they don't like the content or the nature of the event. So that was addressed. Another thing that was brought up in the revisions and the discussions that we had with Edgar Steam Show was around security. There were some questions about the security requirements, so we did bring the sheriff in to explain, and I think I'll let him add to this, or Officer Burkholder can add to it as well. But essentially, this ordinance, including the security section, are drafted for the events and the things that we don't know that are out there. While we know right now that all of our events seem to be operating safely and, they're A+ students in the county, we don't know. We also have to think about events that may come to our county and how we're going to manage new events coming into the county. Would you like to add anything on the security section, or?
No, I think it's pretty self-explanatory. If anybody has any questions, I'd be happy to answer them. I don't have anything specific to add. Just if anyone has any questions, I'd be happy to answer.
So we did have this discussion because this was one of the STEAM show's concerns, was that the barrier might be a little high as it relates to this requirement. Discussion, one of the things we also came up with keeping the ordinance and the security requirements, as that we would suggest to the county board that we try it out for a year. We'll have that opportunity to work with the STEAM show in that first year, and then bring it back for review and look at the ordinance again and see how the security requirements worked and if there's potential for change. So, did you want to add something, Administrator Leonard? Sorry.
Very, very briefly, I think you hit on one of the points, but I think there were two big takeaways. First of all, thank you again, Mr. Banky, for being here. I said he's been here enough times, and that's his spot. We're going to have to get him a name tag. But really, in talking through with the STEAM show and kind of the iterative drafts we've had that Lori and the rest of the staff have put together, I think what we found was there's real value to an FAQ and a user guide, which staff are putting in place, because some of the language in the initial drafts, and speaking with Mr. Banky and attending some of the meetings, the language could have been taken in a way that really the individual, the event holder, might think we're asking for more information than really what we were trying to get at. So I think that FAQ and user guide are really going to be valuable. The second is the point Lori just made, which was the value of the idea of implementing the ordinance and coming back in a year and seeing what that experience is. Like Lori alluded to, we have events like the STEAM show that run very effective events, and we want to see how that ordinance works. And I think when we've looked at what the STEAM show already has in place, I mean, they're 90+% there in terms of all the materials they have, if not higher. It's just going to be working through that first year application process. One of the big takeaways that I think it was Garrett or Shad shared is that once that initial application is in place, each successive year, very minimal, if any, changes should need to be made. So I think that was another takeaway. And then lastly, I just want to thank all the work group participants from the 3 standing committees. ERC supervisors Drabeck and Seefeld have attended those meetings. We've also had supervisors from the infrastructure committee and the public safety committee. And I think that has really been helpful to bring those additional perspectives as well as the outreach to the towns and the event holders. So I think the draft that's before you is workable. I spoke briefly with Mr. Banky before. I mean, I would certainly hesitate to say that every event is going to be like, yes, we really love this ordinance, because it is work. It's going to be a fair amount of work to fill out the application. But I really do think the draft, we're in a lot better place than we were some time ago when we had that initial draft. I thought the discussion around security was really, again, informative and very illustrative of this idea that the user guide is going to be helpful. And I'm hopeful, actually, in that some of our conversations with, particularly with the STEAM show, that we might be able to actually, through those conversations with the sheriff's office, they might find a way to actually decrease their security costs. It's making sure that people understand what the security section and all the other sections, really what they're trying to get at. So I think the user guide and helping initial events through that application process, with which conservation planning and zoning is very familiar with in terms of permit applications. They have that kind of collaborative approach. I think we're in a good spot, but certainly if there are comments, I think the work group would appreciate those if there are revisions that need to be made.
I did want to add 3 more things just to address additional comments here. So as Administrator Leonard said, we do have a representative from the STEAM show here, Kevin Benke, who, if you did want to ask questions of him and recognize him and ask him questions, you could, for sure. As Administrator Leonard was saying, related to implementation, there were a lot of comments in the first round that pointed towards things that we felt didn't need to necessarily go in the ordinance, but certainly needed to go in the implementation in terms of resources for an applicant, because if somebody is coming into our county and they've never done this before. So Garrett has been working on several items that would be available, including an application packet, an FAQ, different resources related to everything from how to write an emergency management plan to how many toilets, resources for figuring out how many toilets you need for your event. So so we do have all of those things that we're gearing up and getting ready if this ordinance were to be adopted. The other thing that came up through the work group and the comments was the section on fees. There were some questions related to fees. On page 61 of your packet is where that is addressed. One of the other reasons, as I understand it, that the county board wanted to take a look at this ordinance was how are we going to account for extra time that might be asked of our highways department or something like that if an event is to come into our area. So we did add a section in there that basically identified that if extraordinary services such as needing something from the highway department for barriers or dynamic message signs, things like that, were determined necessary and the highway department could provide it, an applicant could get those services through a separate contract, and then the highway could determine their fees for that service. So I think those are sort of the 5 or 6 big areas that we discussed in the revisions and were put into the draft that is brought before you now. And again, an appeals section has also been added, which was not in the draft in October. So that's section 16. So stop there.
Supervisor Overbeck.
Another group you could probably reach out to is Trailmates Snowmobile Club, because they hold the Wassa Grass Drags, which draws more than the 3,000 limit. So, and that involves a lot of parking, and I'm a member of that, but and involved with that as well as was Taste and Glow. But there's some issues as far as parking. The number of spaces you're saying like 4 per space. If there's off-site parking, how do you calculate that? Or do you allow for that?
So, excuse me. So in our general zoning ordinance, we do something that's called land banking, where you have, the idea is you're supposed to have set aside the amount of space, square footage wise, in order to accommodate the number of spaces that are required. If you can't get to a point where you have the exact number laid out as far as parking, like if you say you're gonna have 3,500 people there, you get that, but all of a sudden you're out to 4,000 or something like that. We identify areas with the applicant that can be used as additional parking. We've done that quite a bit in the county as commercial things have come up, different parochial schools have come up in the county in the last year. Those are kind of things that we look at as well.
Another question would be, when will this go into, to be enforced? This
So-
year or
Yeah,
next year?
I think that is something we would need to clear up with Corporation Council on the effective date. So
Yeah.
Thank you, Mr. Chair. One of the things that you brought up earlier on is the idea of revisiting this in 1 year, which I think is a good idea. What is the process set up to do that? Does this ordinance sunset automatically and have to be renewed? Or does it just go on autopilot if nothing is done? Because I'm dubious about the let's revisit it in a year because things never seem to go away.
I think it would depend on how we set it up. I mean, we actually take a look at all the ordinances under our jurisdiction on an annual basis for and review. So, but I mean, I think we could put something more official. So, go ahead.
Thank you. Yeah, to answer that question, right now there is no sunset in the ordinance, so that could be something that the committee or one of the committees or the board could add is a specific sunset. We could also put in every ordinance that is approved by the county board is passed with a cover resolution. That cover resolution could require that the ordinance come back within a year for review. Having a sunset directly in the ordinance will, by operation of law, sunset it unless there's further action of the board. So it depends what way you would want to take that. To the earlier question about when would this be effective, as it's written, once it's passed and published, which I'd have to talk to Kim Trueblood about how long that is, but it's typically about a month for publication of ordinances, it becomes effective. You could write in the ordinance a different effective date if you wanted to do that. Those are good things to discuss.
Supervisor Obrecht.
Another question, when the term is used sufficient a number, what guidelines are going to be given to the different organizations as far as figuring out what that sufficient number is to meet the needs of that group? Because I know other communities like Appleton or different ones have some guidelines set forth as far as so many per person. But if it's just sufficient, how would that ever be enforced or even be a guideline for a group to go forward with that?
And which section are you referring to on that question?
Let's see. It's under toilets for one, sufficient number, potable water sufficient for the maximum number of people. I think there's parking sufficient. So that's used throughout the document.
Yeah, so as far as the sufficient number, it's, excuse me, obviously parking is based on the number of anticipated attendees as laid out. Toilets are, again, laid out. I believe the health department has some regulations and things like that for determining how many toilets are needed based on the number of people. So those are the kind of things that are going to be specific to the type of event, the duration of the event. Things like if you're going to have overnight camping, obviously there's going to need to be facilities located in different areas instead of one just general area. So those things are, going to be specific to the type of event, the duration of the event. Things like if you're going to have overnight camping, obviously there's going to need to be facilities located in different areas instead of one just general area. So those things are, going to be specific to the type of event, the duration of the event. Things like if you're going to have overnight camping, obviously there's going to need to be facilities located in different areas instead of one just general area. So those things are built in so that the departments that are reviewing that portion can use the tools that have been provided either at the state level with different statutes or things like that, or best practices that they have, that we can certainly try to add into that implementation packet that we're working on. But that's built in so they can assess the event, the area, the number of people, the different variables that come with different types of events. Because obviously not every event is a cookie cutter situation.
And the health department, I do believe, chose purposely not to be prescriptive there. There is some general guidelines out there, but they wanted to be able to work with the applicant on that. There's other parts of the ordinance where it does say 3 per 1,000, I think, for security. That's coming from state guidance, things like that. But I believe the health department purposely did not want to be prescriptive, so, yeah.
Just in comment regarding that, a lot of these arrangements have to be made way ahead of time, and the application process is, depending on the way that goes. I guess it would be helpful to have resources for events that are just kind of guidelines, giving you a range. If you have food, if you don't, if you have drinks, if you don't, things like that, that can give at least that event a way of budgeting or even reserving those types of facilities.
And they did provide us some resources that we can make available to the applicant, like as it relates to toilets and things like that. So were you going to add something?
If I could, I think part of the reason that we used the language we did throughout this document is because of, as Garrett said, every event is going to be in a different place, time, location. There are a lot of different variables. So having a bit of a reasonableness standard for the review rather than prescribing specific numbers, we thought was more helpful to, first of all, the event planners, knowing that circumstances are different over here than they are over here. And second, for the review by staff, what might be sufficient in one area of the county might not be sufficient in another area. So just giving some, I guess, leniency to be able to work with the applicants to make a plan for parking. And that's the other piece is these guidelines and requirements are really so that the applicant has a plan to deal with parking and a plan to deal with security and a plan to deal with fencing, illumination, those things. The idea is put some thought in ahead of time on what you're going to need based on the amount of people you think are coming. Do you have that plan in place? We'll look at the plan. We'll give insight and guidance as to hey, maybe you want to think about X, Y, and Z. And that way the public safety intent of the ordinance is met. So,
If I could add one other thing, I think your question is very on point, Supervisor. One of the threshold where the group started might seem like the most simple area, but it was actually an area that I think it was good that they had a lot of discussion, and that is on the size of the events that are subject to this. And to your point about, or the point that was made, every event is a little different. If the ordinance is more prescriptive with that information about whether it's parking, toilet facilities, water, trash collection, all those things, you really stratify an ordinance and make it a lot longer, particularly when you look at the size. And if you go to, I think it's on page 57 of your packet, the size of event that ultimately the work group thought was appropriate is an event of 3,000 or more attendees at any one time, or in aggregate over the course of 8 consecutive hours. So you would imagine, like was referenced before, if your event is only 2 hours in duration and you're anticipating 3,500 people, perhaps if your plans with respect to parking and those other items I referenced are fundamentally different than if the event is 12 hours and you anticipate 3,500 people there for that entire period of time. So I think, to your point, the ultimate consensus of that work group was as Corp Counsel alluded to, this idea of injecting a reasonableness standard throughout with a sufficient number of parking spots or whatever the specific area of the ordinance is referring to move to that, to a place where the event holder sits down and they have a plan. Much like the Mr. Benke and the rest of the STEAM show, they have a plan with respect to all of those things because that event has been going on for longer than I've been a resident of Marathon County. But a lot of new events are going to require this ordinance, I think, the way that it's laid out, and then all the other accompanying documents that Lori referenced, are really going to aid them in, these are the things I need to think about. And the parking plan might be fundamentally different for, to your point, the grass drag event that you're talking about versus some other event that perhaps is shorter in duration. But you'll see that language of sufficient or reasonable, and that was intentional. It comes with the trade-off, of course, that in those FAQs and the user guide or application guide, we're going to need to have more of those pieces of information. But in large part, I think this is an opportunity for staff. I mean, we're going to trust the event organizers, at least on the start, right? We're going to have a conversation with them, much like we do with zoning and other permits.
But we will have resources for anyone who's looking for it. So we'll try and point them in the right direction.
The reason I state that is I treat it almost like a building code, in that if you have a building code's the minimum, and you look at it that way, then you can go either way. You can ask for a variance and change it down to a lower with a good reason, or you go up from that based upon that you want to make the people that participate in that event happier by not, waiting in line for everything. So there's that kind of a minimum standard that you have to meet. And I think even the Wisconsin State Code, when you do camping, you've got to go to them as far as getting approvals and get that a permit and make sure you have potable water and hookups. So there's certain things that could be set to at least give a new event organizer, and I'm guessing after a year or two that will kind of happen, because you're going to have standards that are being set that work, and the right amount of security, where some events don't have security. They just will not provide it because they're not used to it. So the event organizers won't do it. So there's things that I think need to be set to meet those minimum standards.
We've got a couple of things, and I do have a question for Mr. Benke. So first couple of things, I would be supportive of a one-year sunset date included in this ordinance, and then the possible reauthorization at that 1 year mark. The other thing I wanted to bring up is under item number 16, which is the last page in the ordinance for the appeal process. Was there a lot of discussion given to why that process would include the administrator ultimately having that final level of appeal? I guess what I'm asking is the rationale behind it.
No, that's a good question. There was a lot of discussion about the appeals section, and the ultimate decision was the approval process necessarily needs to be specifically narrow, because you're going to have an event that has a specific date. We need to have a decision out to these event organizers so they know, what the county's position is on their application. So if there is an appeal, we wanted a specific and short turnaround, and the best way to do that was to follow a similar model that is present in some other areas of our ordinances, which is to have those appeals go directly to the administrator so you can make a quick turnaround decision.
Yeah, and I can understand and respect that, but I really think that it should ultimately, believe it or not, end up at ERC, because I don't think the administrator should get involved in those community disagreements. There's politics there. I'd rather have that come in front of the ERC, and they would be required to meet within a certain amount of time after the receipt comes to the county, and they would make a final ruling. That's what I would rather see. And if I'm wrong, please feel free to tell me.
I'm not looking for more work. But as Corp Counsel alluded to, there are other areas of your statute, or of your ordinances, excuse me, where that similar process is used. I have written very riveting appeal decisions on requests for opening of various sections of roadway for utilization for ATVs. I'm happy to share any if you want some, again, riveting reading. One of the areas, and Corp Counsel can elaborate on it relative to appeals, is this is an area, one of the areas where our previous ordinance was unconstitutional or raised great concern was that very part that it would come back to a committee. And I'm not saying that a committee can't make a very well-rationed decision. You do it with zoning, as you did
Yeah,
earlier
we do it all
today.
the time here.
Yep.
Yeah. Maybe not the other committees, but this one does.
Yeah, this one does. Some of the challenge that may exist relative to events is that any decision relative to an event cannot be based on the content or specific utilization of the event itself. So that was discussed. I'm not weighing in one way or the other. I have more than enough through the work plan to do. But I don't know, Mike, if you had anything you wanted to elaborate on the discussion that was.
Well, the other thing I was just going to add, and Mike, feel free to go ahead, but I don't anticipate there being a lot of appeals. There probably isn't, practically with this ordinance, there probably won't be that many. My point is, I'm afraid of that line, that blurring of like, there's an upset citizen because they didn't get their event and then they're mad at the administrator. I'd rather have that feedback go to their supervisor rather than the administration. So, Mike, sorry.
Yeah, so to Lance's point that he just made to me, if the administrator is involved in an appeal as it's currently written, if the citizen is aggrieved by his decision, they have the right to take that to circuit court. It's not written in here, but that's just how the law works, which is similar actually to a lot of decisions that are made by county staff. There is an appeals process. There's an internal appeals process that goes through department head. Depending on the ordinance, it could go to a specific administrative review board, or it could go to a specific review panel. But ultimately, if someone's still aggrieved by that decision, they have the right to petition circuit court to overturn a county decision, depending on what that decision is. So that avenue is still available. To your point as to whether it could be rewritten to have the committee be the arbiter of the appeal, certainly could. We would have to make sure it's written in a way to alleviate some of those constitutional concerns specifically about timing, making sure that an appeal to a committee wouldn't unduly delay the decision, because ultimately we're dealing with First Amendment rights here, rights to assembly. We have to make sure that those are dealt with timely.
But wouldn't there, I didn't mean to cut you off, you had more, but I was just going to say, wouldn't there be timing concerns if they went to the administrator, they didn't like the administrator's final ruling, and they went to the court anyway? Because, I mean, getting something scheduled in court would just keep delaying that process.
Well, I mean, yes and no.
Okay.
The timing concern I'm talking about is how our ordinance is written. Now, ultimately, everyone would have the right to petition to circuit court. Circuit court would have to decide whether to set emergency hearings and expedite that timeline if there's a constitutional challenge. But if we specifically put in our ordinance something that is not specifically connected to a legitimate government interest in having it go to a committee and having the committee decide, a court could say, well, you're unconstitutionally delaying the process. I don't know that would happen. It would depend on what our timeline would be. So it's certainly something that we could write in there. We just have to figure out what the wording would be.
All right, now my question for Mr. Benke. So, I've been to your event before. It's a very good event. It's a very well-run event. When we were having these discussions, I think that was back over the summer when this initially got brought in front of us from the work group's work. And we had requested that there be input provided from specifically the Steam Show and the Taste and Glow. And one of the things that, in my mind, was important, and especially now it's very important because we don't know if the Taste and Glow is going to, have an event anymore. With this ordinance, can it benefit your organization?
I don't see any benefits because we
Well,
don't.
it's an honest question because
No,
right now you would be
it's-
the only group that would be impacted.
Right. It's a lot of paperwork. A lot of paperwork. We do probably 95% of this, what's in here already,
Okay.
like the bathrooms and the water and the trash, that's all covered under health. And even your health department, even the camping, the health department in state sets those regs already. And the health department makes sure we have that take care of it. They do a lot of this already and stuff. This is gonna be a lot of paperwork, particularly when we gotta start listing our food vendors and stuff that show up. I know the health department, they come a day early and they inspect all of them there when they do inspect us and stuff. That's probably the biggest thing is the paperwork burden. Make sure everything comes out right. Stuff. Just to backstep an appeals process, we only have a 40-day window here.
Sure.
So if there's somebody going to say no on something, that we got to have an answer in a couple days, not a couple weeks.
Yep.
We only have a 40-day window on this application.
Okay. So then I have two things. The first thing is I'm willing to retract my comment about ERC if that gets this process resolved quicker. That's fine. The second thing, and I'll get to you, Supervisor Stravinsky, is the 5% the paperwork, or is the 5% security or another area?
Property things we got to buck up is property security. And we only had the cops there once, or a sheriff's department once there in 50 years. So that tells you what's going on.
Sure.
And the other thing is just how are we going to administrate this, you know?
Yeah.
I could see a few days' work here.
Sure. Supervisor Stravinsky.
Thank you, Chair. First question, and I've been out to the STEAM show for a number of times, going way, way back. And so what I've seen is it's evolved over many, many years. It started out much smaller, and you've just grown and you've learned over the years. The last couple of years, what is the attendance?
Last year, we had 12,000. That's paying, okay? Now, there's probably another 500-600 of volunteers. I should explain, our show is just to make money so you can put on another show next year. We try to support, our priority is when we hire vendors and stuff, is hire local nonprofits. They get first priority, whether it's the FFAs, the 4-H groups, the church youth groups, and stuff like that. They're all first in line. Then if we can't find anybody to fill, then we look into the commercial avenues. So, if it rains, our attendance is probably 3,000.
So in a good year, though, you're looking at an attendance that's easily 10,000 people over 3 days.
That's correct, yes.
Okay, so which brings me to the observation that I wonder if the 3,000 number proposed in the ordinance is excessively low, because the STEAM show and the grass drags evolved over many years from small events that were several hundred or 1,000 people and grew organically to the point where all of a sudden, oh, look at this, we've got 5,000 people this year. The Taste and Glow event is something that's an outlier. And that may be part of the challenge right now that they're facing, trying to continue, is that it grew explosively. So I'm wondering if this ordinance is going to be rather than solve a problem, is going to create problems and create barriers to having small events that start out with 500 or 1,000 people and just percolate along for a year or 3 or 5. And they may grow, they may not, but I'm thinking that this is an obstacle rather than solving any problem at this point, at least at the 3,000 level. Maybe if we look at raising the number to 5,000, might be more appropriate.
Sure. I think that's why the work group started with that exact point. I think that there's a lot of discussion. Staff pulled a lot of ordinances from other counties that had addressed some of the constitutional concerns Mike had referenced already. And they did range from, I can't remember off the top of my head what the lowest number was, but I want to say there was one that was 500 or 500 to 1,000 on the low end and maybe 5,000 on the top end. Ultimately, I think Mr. Benke's experience and your question, Supervisor Sherfinsky, again, is very on point. When you look at the event like the STEAM show, it's 12,000 on a good year over those 3 days. The way the ordinance is written is to try to get at that sweet spot, but certainly it's the board's prerogative as to what that sweet spot is. And the work group came up with that idea of 3,000 or more as measured at any one moment during a day or over an 8-hour span. So if you had, it's kind of that 3,000 as a daily event, which on a good year, and I hope all the years are good, you're hitting that every day at the STEAM show. But on a day where there's rain, perhaps maybe you fall underneath it. So that was the discussion, but certainly the county board can change that. Again, I recall one of the ordinances that we looked at had a different measure for, and this is to Supervisor Oberbeck's earlier point, if you really want to get complex, you can say at night it's this number of people that we care about, and during the day it's this number. But the work group ultimately decided to go into that more general measure of 3,000 people at any time or an aggregate over 8 hours. If your event is going to go 12 hours and you don't expect to have 3,000 people at any one time or in the 8 hours, you actually would not fall in this event under this ordinance. And I did want to just clarify one thing on I think Mr. Benke made a great point about the 40-day time window. I mean, there's nothing stopping anyone from getting an application in earlier and I hope when we get the STEAM show, we work with them on their application. Once it's done, the paperwork our goal is it's easier for you next year than it is even, the following year than it is now. But you can turn in that application 6 months in advance if you wanted. It's just one of the constitutional concerns that with our previous, with our current ordinance, is that the timelines could subject us to suit for having an unreasonable restriction on freedom of assembly because the time frame was so long that you needed to have your application in so far in advance. And the idea is that you don't want to unreasonably infringe on someone's ability to assemble. So the requirement is that they have the application in within 30 days of that. Or are we changing that to 40? Is that what we're changing to?
So the requirement is that the application has to be submitted at least 40 days prior to the event. They can submit earlier, and then there is a specific time frame for the staff review to be completed so that there's an expectation that it's not an ever lengthier review process.
Sorry to go down the day thing, but I wanted to make sure we came back to that. But on your question, Supervisor Sherfinsky, absolutely. If the board says, hey, 5,000 is the right number, that's entirely the prerogative. The work group ultimately just settled on keeping that number actually the same. Your current ordinance is 3,000 people. The language is a little different, but that same idea.
Thank you, Mr. Chair. I just wanted to add, just to expand a little bit on the legal perspective. When I was tasked to contribute to the work group, my main concern was addressing those constitutional concerns in our existing ordinance. So to me, that's really important that we don't have an ordinance on the books that raises constitutional concerns and potentially creates liability for the county if it was enforced. As far as what action the board or the committees take, I think the first question is deciding whether to regulate at all in this space, because you don't have to regulate. If you choose to regulate, you have to regulate within those constitutional confines of giving specific timeframes and making sure that you're not unduly infringing on the rights of free speech and assembly. So I think the discussion of, what number is really the appropriate threshold is a good one. It's really a good policy question that we have to take into account. Any decision that we make on that number, we need to relate it to, okay, why are we regulating these events in the first place? So is it because we want to make more paperwork for everyone? That's not a rational governmental interest, so that's not a reason to regulate. But if there's a public safety reason, which is really why these discussions, I think, have been happening, what's the number that really triggers that going into place? So the discussions at the work group were that 3,000 number seemed like the number, but that's really one of the policy decisions we need to make. Sure. It doesn't apply in incorporated areas.
Yeah, because, Wausau's got space for 20,000 people for an event, No, I respect where the intent came from, which is to look at the existing ordinance and figuring out how to, shield the county from potential liability. I respect that. I guess my next question would be, and then I think Chair Gibbs had a question. I'm going to ask the question first. So it's going to probably be two questions. So you already have security at the steam show, correct?
Yes.
Okay. So this would be a question for our law enforcement folks. If there was a situation where police needed to be dispatched there, what does that response currently look like, and how does this potential ordinance help that response?
As far as a response, it would depend on what it is and how many people we have working in the county. If
Sure.
it's, say, a fight or a disorderly conduct or something like that, we're going to send a minimum of 2 cars, possibly more than that. And we'd work hand in hand with the security. But obviously, it's a legal matter. We're going to take precedent over it.
So then, with this, with the ordinance, then, how is the process improved then? Does that make sense?
Yeah.
Okay.
I guess for one thing, it should be peace of mind for the people that are attending there to know that there's security. And it takes a little bit of a burden off of us, because a lot of these events will call us ahead of time to let us know that they're having them. So we'll do what's called an extra patrol request, and we'll have cars kind of hang out in the area or drive by when they're free. When we know there's security, we kind of back off on that a little bit.
Okay.
So it frees resources for other things.
Yeah, that makes sense. And then I think the other thing I was going to add is that I saw in the document that there is a requirement that contact information be provided. So there would be a point of contact for your work, and that if there was a call that came in, you would know that point of contact, who's out there in the response. Does that make sense?
Yeah.
Okay.
I believe Sheriff Billup would also like to address the security question.
Yes.
Just to address one other quick thing to that last question you had. This ordinance, the work group did not focus on the steam show. I want to be clear about that.
Sure.
That they do things very well out there. When we were working on this is for a group that just starts up and they want to come do a large event and they aren't even thinking about security. So what this ordinance does with the security component is it forces them to think about that. And that's why we've said, we're not mandating that you contract with the sheriff's office. We're not mandating that you contract with a security company. You can do this on your own. The one piece we have in there that if you do the permit through, I'm going to butcher this, but the Wisconsin Department of Standards, Professional Standards, Safety and Professional Standards, they actually require a component, which is a background check, just to ensure that the people that are providing the security are the right people providing security, that we aren't having a family event and inadvertently we have somebody working security that's, say, on the sex offender registry, something like that. So that's why this was put in there. It's meant to be put in. I think that that permit is a 5-year permit, and it comes out to like $5 or $6 a year per person in order to have that permit. So it's not a huge burden on an organizer or a group, but yet it sets the checks and balances in place. So that's what this enhances.
Okay, thank you. Chair Gibbs.
I guess the sheriff made my point, and that was, I think, even though this does entail and does bring into the ordinance the steam show, I don't think that that's what the intent was. I think we had other potential situations in the county that might have, fallen under this ordinance because of their original decision in the potential number of people that there were going to be in attendance. So I think that's what this ordinance is designed to do, is make individual organizers actually think about all of the items that are in the ordinance. I think a compromise that we're offering right now is a trial to see where, if there is burdens that are being put on, for example, the steam show, that we can at least bring those out and bring those potential changes back to the ordinance in 1 year. So, I think the key is that we're looking at not specifically the entities that are currently doing a fabulous job in holding their events, but individuals that are potentially coming in and looking to have an event.
And I want to be clear, I don't want to give off the idea that I'm suggesting, or I don't want to give off the suggestion that the steam show is being targeted. I'm not. I understand that there is a valuable purpose that this ordinance could play if there was a brand new organizer that wanted to start up an event. I get that. My point is that if we get to a year from now and they're the only ones operating that fall under this ordinance, that's the part I struggle with, which is why I want them to benefit in some way from this ordinance being in place. Might not have to be a direct $5,000 benefit, but I would like the idea of some convenience granted to them with this being in place. That's what I'm getting at. Has the work group talked about that at all?
As far as, your question, yeah, with the work group, I think we, like Chair Gibbs had mentioned, that we have, as a work group, we've looked at the ordinance as a countywide, not just the steam show, not just Taste and Glow, but as a planning document that's being created for those newer events that, like Sheriff Bill had mentioned, that have not addressed certain things, security, toilets, those kind of things. I just wanted to add one more thing to Chair Gibbs's point, is that under this ordinance would be kind of the umbrella that the steam show would put their application in. If this ordinance is not approved, they would still be doing 95% of this anyway, being under county zoning. Since they take place in the town of Wien, they submit these kind of things to us anyway. They have to go through the health department. They have to fill out an application for county zoning. So, like I said, they're doing 95% of this ordinance as it sits now.
If I can add one thing I think your question again is a good one, and I hope this is kind of one of our guiding principles, that at least from the staff side, and I know the work group alluded to this, the benefit that we're aiming for with this is it's, as Garrett alluded to, the one-stop shop. It's no longer going to be incumbent on Mr. Benke and everyone else to go to the various places to do the things. Certainly, if there's a camping situation, the health department has, as Supervisor Oberbeck alluded to before, there are state regulations with regard to overnight camping. But where we really drafted this in our implementation plan, kind of my direction is that we want to take all of the question about where do I need to go next if I'm an event organizer, staff are going to be the ones serving as the point of contact. It's going to be clear. You go through this planning exercise with conservation planning and zoning. We're going to route all the necessary individuals to you to review that application. So that's the hope. I know Mr. Benke, we're talking a lot about the STEAM show. The first year of the paperwork, I think, is going to be, it's a new application compared to what they would have before. But again, the goal is, should the county board decide to regulate in this area, that long-term, the paperwork is a lot easier.
Well, and I'll get your point, Supervisor Stravinsky, but I think it's valuable for the county to regulate in this area. I do. I don't want to give off that impression either. It's just, if we've only got one actor right now, how do we make sure this isn't burdensome? That's what I'm getting at, because they're already doing a good job. Did you have something to add there, Commissioner?
Just to add, going back to Supervisor Sherfinsky's point, I think that the other thing is setting that that threshold at a level where you're not regulating beyond what the county board thinks is the appropriate level. I think to Supervisor Sherfinsky's point, if you do have an event that is starting up and they're only going to have, whatever the number is, if it's going to be 2,000 people, you don't want to overly burden an event that perhaps doesn't need it. Again, the county board is the one that is the entity that figures out where that level is, though.
And don't get me wrong, knowing, how my future sometimes can play out in the next 6 months, there probably will be 3 events that pop up like this. And I don't want to go to any of those events and there, be safety concerns or health concerns, because guess what? That makes Marathon County look bad. It does. Supervisor Stravinsky.
Thank you, Mr. Chair. I think the discussion is really good, and I also want to make sure that I don't come across as completely negative. I think the point that the administrator made about being a one-stop shop and providing guidance is absolutely excellent. The STEAM show managed to learn over a number of years. The snowmobile grass drags have learned over a number of years and have grown. To have an event that pops up and starts out relatively small and grows quickly, there'd be a lot of benefit and value in that. The question that I guess I'm going to come back to is, how many events do we have that would...
Get off my foot.
How many events do we have that even cross, let's say, 1,000 or 2,000 participant threshold at this point? How many events are we remotely looking at as potentially being impacted, either today or maybe that would grow in the future?
So events that are at like the 1,000 to 2,000 mark, is that what you're asking?
Well, right now I think this all came back partly because there were constitutional questions and partly because the Taste and Glow event exploded astronomically.
We know,
and that then said, we have the Taste and Glow. The only other event that really comes under the purview of this at the moment is the STEAM show. Do we have any other events happening in the county that are remotely close to triggering this ordinance?
It looks like Sheriff Billup has some data he wants to share.
I can give a couple of examples, and I want to help answer your question too as well, Supervisor Langenhahn. I think about, there's a concert venue on the east end of the county that every once in a while they'll advertise that they're bringing a big band in. I think they actually had Ted Nugent one year. And all of a sudden that will bring in a huge influx of folks. So it's for when those things pop up that we're not anticipating, this helps inform our response and what we might do. But I want to, what your question was a good one, and you're basically asking, what is the value of an ordinance like this? What is the return on investment? And having been very involved in Farm Technology Days in 2011, and then seeing in the record review that we're hosting in 2026. So in 2 years, that planning is going to start in the next 6 months, probably. As soon as they wrap up Farm Technology Days in June or July this year, we're going to start planning for Marathon County. If this ordinance is in place and you have this roadmap in place, you're going to expedite the process for the organizers of Farm Technology Days when they come in and we become the one-stop shop to help get them to where they need to be. I don't know of anyone, unless your dad is still involved in wanting to be a part of planning that, but I'll tell you, that is a huge undertaking. I don't know of many of the same people that are going to be involved in planning this year's event, 2026 event, that were a part of the 2011 event. So I think that having a roadmap in place is there not to restrict people's ability to have these events, but to help inform how to make them successful. Does that help answer the question a little bit?
I think so, to a point. I look at it and it's interesting that you should bring that one up because I attended that this past year for another reason. But I also look back and I go, okay, so were there any problems back in 2011? Every time we create an ordinance or a layer of government, I look at it very skeptically, and my question always comes back to what problem are we solving? We're imposing a burden on everybody involved, usually. In this case, maybe we're imposing a burden, but we might actually be providing a help too. That how-to aspect is not to be understated. But we are also imposing a burden, and are we imposing a burden unnecessarily, or are we doing something that ultimately benefits everybody in the county?
If I could add a little bit, I think, again, good point for some additional context. So this project, believe it or not, its genesis predates me as the administrator, which maybe is not that surprising. Going back to kind of what was the problem that was attempting to be solved back in, I think it was 2018, this discussion, 2018 or 19 when it started, there were kind of a proliferation of events, the growth of the Wausau Marathon, other running events, Iron Bull with some of their events, the Ragnar event. More and more of these outdoor recreation, largely focused events were coming to Marathon County, and the discussion took place at both, I believe it was infrastructure and at public safety about, geez, we really need an ordinance to some guiding principles to how to handle these. And the administrator at the time started work to craft an ordinance for the committees to look at. The other part of this, what problem are we trying to solve, was the idea that Lori brought up before about how do we handle when there are those requests, like Tim shared about a request for services of the sheriff's office or the highway department, some guidance on, well, these are taxpayer dollars that support county offices. Should they be going to support an event that doesn't serve perhaps everyone in the community? So there were those two things that led to this conversation. And lo and behold, we didn't need a new ordinance because we do have 12.04, albeit 12.04 is in dire need of a lot of changes, which is to Mike's point earlier about constitutionality and process concerns. So that was kind of the start, was how do we deal with these events if you're going to have a large marathon that is maybe going to start in one community, or a triathlon. I remember Gina Cornell attended these initial meetings, and she was working on having a large triathlon before the pandemic. And of course, with a lot of things during the pandemic, some of those events changed. So that's kind of the genesis. It goes back to this idea of how do we help those event organizers move forward? The second piece has always been that, we get requests from an event to assist, whether it's the sheriff's office with, the kind of periodic patrols that Tim referenced, or traffic control, or the highway department. Jim might get a call and ask for those dynamic signs or barrels to be set out. Some guidance on what does that look like? When do we do that? And what cost recovery do we aim for? The Parks Department runs a lot of events, so we kind of followed that approach with those events when the work group discussed this ordinance. But that idea of having separate contracts for those specific requests of county departments, I think is again a good model, as opposed to hey, we're putting on this event, we're going to have a bunch of people running down Highway N, or a gravel bike ride from one town to another. You guys should be aware of it, and you should be out there doing traffic control. It's like, hey, we don't do that absent a separate agreement. So that kind of again gives some, I hope gives some insight to your question again, which is a good one. Why should we consider regulating in this space and updating our ordinance? Excuse me.
Thank you, Mr. Chair. The group of people that we're not talking about here that this will benefit is the people that live in the communities surrounding these events. They might not be going to the event, but they're going to be affected by it. And I think if we give guidelines, it'll not only help the organizers streamline their planning, but it'll give the people that live in the communities where these are held a little confidence that, hey, the county's not going to let this get out of hand.
All right, Supervisor Drabeck and then Supervisor Obrecht.
Thank you, Mr. Chair. To Mr. Ritter's point there, back when I was way younger, like a teenager or less, and I lived south of Hayward, there was a big rock concert that went on, and I could hear it for 5 miles away. Now, I enjoyed it, but I don't think all the neighbors did. But so that's a good point for that. I just want to thank the guys from the Steam Show for showing up and all their help with this as well. And would you be willing to come back in a year and see how this worked? Yeah.
Yes, I will be.
Appreciate that. Thank you.
Supervisor Obrecht.
I think what's also needed is when I participated in just a plan review down in Madison, they had all the departments over Zoom or whatever when we were doing it, but you submitted the documents and you got feedback from every department all at once. And it immediately moved that event forward, or not the event, but the plan forward. And I think that's some of the guidelines that need to be here too, is what documents need to be submitted, how much information, what's good, what's bad, examples, so that event organizers can put forth all of that information and get feedback as fast as they can. Because what goes on behind the scenes at some of the events, like Taste and Glow, I mean, we ended up putting a 3-lane exit out onto, I think it's 120th, to alleviate some of the issues that happened when traffic backed up almost onto Highway 29 the year before. So there's things that are going on that take a lot of time, a lot of effort to plan out. And just even in parking, on the Trailmates property, we can park about 2,100 cars. Multiply that by 4, that's only, or 8, or 4 in a car, that's only 8,400 cars, or people that can enter that from that property. So that's one reason the event is really at risk right now, is because of the parking, because we had another maybe 50 acres on the other side that we could utilize. So we've got 80 acres that we filled with events. So it's just a matter of all these events growing to such a stage that you have to start adding more and more. I know the Sheriff's Department was out there with a command center. We had fire departments that were reacting to anything from dirt in the eye, which one person had, to just little scrapes, or even lost children. on how to react to that. Communication, we had 12 radios going throughout just on our personnel out there. So there's a lot of behind the scenes and communication devices that we need, communication between all parties, and just how to handle an event like that. So the more this organization could act as an advisory board to that event, the better it's going to go, and the pre-planning that happens. So I guess if that could happen, rather than going to individual departments and getting feedback, it helps to have that discussion. And another question would be, do the towns, like we went through the town of Stettin for our event, for the Trailmates event, would that stop then, or would they be part of this advisory or regulatory board?
So if a town does have their own ordinances related to holding an event, the applicant still has to follow those and go through their process as well.
Okay.
Does that answer your question?
And then it would come to Marathon County after that?
We usually encourage that they concurrently would approach us at the same time in terms
Okay.
of like getting their information in. So, and then, I mean, the towns are not a part of approving our permit. They could appeal it, but they don't.
Yeah, but they would have ultimately the say whether that event would happen or not, because they also then get the community input, what was stated by Mike, as far as whether those people around the event support it, and what, I guess, compromises would be made regarding the event, hours of operation, noise, things like that.
Are you asking, like, does one ordinance trump the other? Or, I'm sorry.
Well, if it gets approved by Marathon County but doesn't get approved by Stettin in this case, what happens?
Mike, I assume that it's not approved then. I mean,
Right.
Yeah.
If there's an applicable county ordinance and an applicable town ordinance, and the county issues a permit, but the town doesn't, they can't operate in the town regardless of the county. Like, we can't trump their approval. But it depends what the town is regulating. The town has different authority to regulate in different areas than the county does. So, but there could be some overlap.
Well, the town, I think, is going to be way more limited compared to what the county can ask for. So,
But
sorry,
that-
Supervisor.
But that would be coordinated between the town and the county as far as how this ordinance would be work with the town's ordinance.
Can I, so I think your question is a complex one, and because there was an example of the involvement of Stettin in the previous Taste and Glow. If you look to the exceptions section, which is on page 3 of the ordinance or page 58 of your packet, it talks about this section does not apply to government-sponsored events held on governmental-owned property where the proceeds are returned to the government. So in certain instances based on the property that would be utilized, and if it was governmental sponsored, it would be exempt. Mike can talk, or we can look into perhaps the interplay between the town, if a town has an applicable ordinance and the county does, how does that work? The interplay between the town and our ordinance, and I think Lori was alluding to this, correct me if I'm wrong, but that we provide notice of any event, getting to Supervisor Ritter's point, we're providing notice to the town because it is certainly not, I would hazard to say that always happens with events. There are probably a fair amount of events that don't provide notice if they're happening in certain areas. We, through our process, will provide that notice to the town. And they are referenced within the appeals section that Mike referenced before. With respect to your earlier idea that I really like that idea of like a round table when we have an event application come in, whether it's literally get around a table or do it via virtual technology to talk through with the applicant. We can certainly include that in kind of our operations guide or our practices. I don't know that it has a place in an ordinance to talk about how we're going to do those things, but I think that's really good feedback from the event holder perspective, and if anybody else has any great ideas like that, please share. We are all about ripping off and duplicating.
Yeah, just a clarification, that's all on private property, but it's approved by the town with that. But that's a question as far as the town of Stettin will have, we've been working with them for 30 years on the grass drags and whatever with probably over 6,000 to 8,000 people. But they've also approved the Stettin, but we've also worked with Marathon County on the Taste and Glow when we've had it there. It's just a matter of which, once you go to one, which there's no issue, but then Marathon County might have a different way of approaching that ordinance or what's required on site to have that event, which one, I'm sure that's going to be coordinated as we move forward.
Sure. And I don't know that I can give you a great answer, but the reason, going back again to why perhaps there's a value in having our ordinance, the county's ordinance, because the entity that will be tasked with responding is the county sheriff's office as opposed to a town. They're not going to have their own law enforcement. They're not going to be doing the dispatch for the fire and EMS. Should there be a large-scale event, our staff will be doing that. The highway department would be responsible for any highway-related incidents or services that are requested should we choose to contract for those, as opposed to, a town government certainly can sponsor an event that's envisioned in the ordinance, but I would, correct me if I'm wrong, Mike, if a town has a specific permit process, and I'm not aware, but it sounds like the town of Stettin does, and the county has one, the event holder would need to be in compliance with both. Always good when the lawyer nods after I say something.
Did the work group ever look at the town of Stettin's ordinance?
No, we did not.
Other comments? Good discussion. I know it's gotten lengthy, but this is good discussion. I can support the 1 year up for renewal. I'm fine with that. And of course, we would welcome the feedback from the STEAM show after that 1 year to assess the burden. And I'll retract what I said earlier about the appeals process, but that's about where I'm sitting. Although this town of Stettin ordinance is bugging me, I tried to look it up here, but they don't have their ordinances on their website. Because we also don't want to duplicate things either. So if they're already asking for information that they have to provide to us beyond just like event name and.
It's a simple ordinance. It's not.
So it's not comprehensive like this would be? Okay, all right. So I could fill it out, that's what you're saying. Okay. Yeah. So that's where I'm sitting at. Staff, is the work group done with their work, or where are we at with that?
So at this point, it's going back to all three of the standing committees, and any one of them could choose to move it forward to the county board for consideration, correct?
They could, but also if you have directions specifically about the 1 year sunset provision, you could ask the work group to take that back. It is still on the agenda, I think, for the other committees, but I think staff could inform those committees of ERC's action as to their recommendations.
Well, this is what I'd like to see. I'd like to see the 1 year sunset added with the possibility of reauthorization. I'd also really like to see, Supervisor Obrecht, I trust you, don't get me wrong, but I still want to see the town of Stettin's ordinance. So if we could get a copy of that, that would be great. See what they asked for already. And that's about where I'm sitting at. Anybody else? What they'd like to see? Chair Gibbs?
Yeah, I think the one thing that we need to be clear about, though, and I'm not trying to be overburdensome for what Stettin has, but we also, this covers the whole rural portion of the county in towns that don't have zoning, towns that do, towns that have county zoning, towns that have town zoning. So even though the town of Stettin may have a section in their zoning that covers events like this, the town of Holton may not, or other towns may not have any zoning in that. And
I'm just asking for Stettin.
Absolutely.
That's it. Just as a small sample. That's it. Anything else? Okay, so we'll see this back probably next month. Thank you, Mike. Thank you, Lance. Thank you to the Sheriff's Department for being here. Thank you, Mr. Benke. We appreciate your time and all the other time that you put into having the discussions with the work group. We appreciate the feedback.
Thank you.
All right. All right. Moving on. We've got 7 educational presentations, outcome monitoring reports and committee discussion. A, department updates, CPC, Park Rec, Forestry, Solid Waste. Hey, there's 2 pages to this. There we go. General core ordinances for Marathon County, overview of draft updates, Chapter 15, private sewage systems, Chapter 21, non-metallic mining reclamation code. I think we got Shad, right? Yep, turned around, there he is. All right.
All right, so like the last meeting, I just have the table here. How we left it off last month was these ordinances were in review for the state. The state has to do a review on both of these ordinances and essentially give us approvals to move forward onto like the public hearing aspect. So give a quick timeline. October of 2023, we sent a memo out that these would be in effect for, which is all towns and county zoning, non-zoning, and Chapter 15 is also included in cities and villages as well. December, we had this table of revisions created as well as a draft of the ordinance. And then we also sent the draft along with this table to the state to get their input on it to make sure that it abided by their standards as well. Just they kind of double check our work. In January of 2024, we just this week, we received approval from the state saying our changes were approved by them. So the next step is essentially the public hearing for this. So what we did is we noticed all of our towns again, sent them the draft ordinance. The link to the draft ordinance is actually on our website right now for them to view. We are requesting that they provide input to that as well. We do by March 1st is when we have their date to provide us input by. We do also have an open house opportunity on February 21st. For towns or individuals interested to come in and talk to us about the changes of these ordinances, with the hopes of in March to have the code adopted or ERC to approve, and then it be moved on to county board for their final approval. So with the expectation next meeting, we would be bringing forth the official petition essentially for these codes. With that, we'd bring forward any comments that we did get from the towns for this with this input process. So both the Chapter 15, which is our sanitary code, was approved by DSPS, and then our non-metallic mining code was approved by DNR. Nothing major is changing in either of these codes. Nothing crazy has been proposed. Most of it is defining, adding clarity to the ordinance, and then replacing statutes that no longer exist or live in a different area of the code. So, like I said, the draft ordinance, it's on our zoning page on our website. We can definitely get a link out. I believe there's actually a link. Yep, right on the bottom. You should be able to click the link at the bottom of this page, and it'll take you to the page where those drafts live.
And also among those changes, taking direction from the state, because I see that was marked in the column as well.
Correct, yep.
Yeah, okay.
Yep.
All right. Do we have to have a public hearing on these next month then?
So next month would be when the public hearing would be for this. So we would have, it would just be your standard. It's like how we do Chapter 17. It'd be the same process.
Okay. Any other questions? All right, seeing and hearing none. Thank you, Shad. 8, we got nothing. Next meeting, March 5th, 2024, 3 PM, Assembly Room and future agenda items. Committee members are asked to bring ideas for future discussion. B, announcements, requests, correspondence. I have got nothing. Staff, do you have anything? Nope. All right, number 10. Motion by Seefeld, second by Supervisor Draybeck. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed? Motion carries. Thanks, everybody. Thank you, staff.
This meeting is no longer being recorded.
Actually, can I borrow this quick? I always do. I really need to bring a pen. One thing I know with ERC, I'm going to end up signing this.